Good day, this is Professor Jacobs. Today I'll be teaching on the general principles of insurance contract law. We'll be dealing with Learning Units 1, 2 and 5, and we'll call this Part 1 of the lecture on Learning Units 1 to 5. This is an overview of what we'll be dealing with today. Focus on the parts in bold. You'll need to take a look at Tutorial Letter 101, the study guide, as well as Tutorial Letter 102 that contains amendments to the prescribed tutorial matter. Learning Unit 1 deals with the concept of insurance and related matters. You'll need to study Learning Unit 1 from the study guide, the prescribed parts in Reinecke et al., as well as from the tutorial letters. Also focus on Tutorial Letter 102 with the changes to the prescribed study material, as well as the additional prescribed materials that's listed there. As an introduction, we need to start off with some important concepts: the incidence, management, and spreading of risk. So what is the spreading of risk? That is to distribute the risk of occurrence of undesirable events among a number of people. And insurance in an economic sense? Insurance is an instrument to spread risk among people with the same comparable dangers or risks. Study those parts from Reinecke et al. And then also cross-reference to Learning Unit 9, where you'll study risk in more detail later on. The previous slide has already dealt with insurance in an economic sense. Now you need to distinguish insurance in a legal sense. To know what that means, you'll need to know the definition of insurance. And that comprises of the essentials of an insurance contract, which we'll deal with more later on in Learning Unit 3. So for the moment, study those parts in Reinecke et al., and in the next lecture, you'll learn more about the essentials of an insurance contract. There are many different classifications of insurance contracts. One of the most important is the difference between indemnity and non-indemnity insurance. In indemnity insurance, the indemnity principle is applicable, and it's all about making good the loss, to indemnify you against the loss that you've suffered. Whereas in non-indemnity insurance, it's about compensation, non-patrimonial matters. See more about this and study from Reinecke et al. Also cross-reference to later learning units where you learn more about, for instance, insurable interest in indemnity insurance and non-indemnity insurance in Learning Unit 6. The principle of indemnity, subrogation and salvage in Learning Unit 12 and 13. Those learning units are very important as far as indemnity insurance is concerned. The new Insurance Act 18 of 2018 distinguishes between life insurance, which was formerly known as long-term insurance, and non-life insurance, formerly short-term insurance. And it also contains classes and subclasses of insurance business. On the slide, you'll see that Section 2, Table 1 provides for classes and subclasses of life insurance, whereas Schedule 2, Table 2 provides for the classes and subclasses of non-life insurance. Refer to Tutorial Letter 102 for more about this, but please note that the PPRs, namely the Policyholder Protection Rules, even the newest ones, still refer to long-term insurance and short-term insurance. The Insurance Act also introduces a legal framework for microinsurance. See the definition of microinsurance business in Section 1 of the Insurance Act. Read it with Schedule 2, Tables 1 and 2, because microinsurance is not limited to only one kind of insurance product. Also refer to the October 2018 PPRs. Those PPRs contain more detailed rules on microinsurance, both in the context of short-term and long-term insurance. It's important that you cross-reference to Tutorial Letter 102 for the changes to the prescribed study material of Learning Unit 1. Also then attempt to do the question, distinguish between life insurance and death insurance. Remember, the new classes of insurance. We'll now discuss Learning Unit 2, the sources of South African insurance law. You need to study from the study guide, the prescribed textbook, the article by Van Niekerk, the Oudtshoorn municipality case, and then the next slide also contains the new prescribed materials. Refer to Tutorial Letter 102 on the changes to prescribed study material, and also study the new prescribed materials. Add here too also the article by Schultz. Please take note that for purposes of South African insurance law, Roman Dutch law is the common law. That's binding. That's according to the Oudtshoorn municipality case. Read that case also in regard to many other issues. As we proceed, you'll see why the case is so relevant. Then further, English law is our foreign law and merely persuasive. We use it for comparative purposes. Study those paragraphs from Reinecke et al. Attempt to do this question. Custom and legislation are also very important when it comes to the sources of insurance law. And you need to study those paragraphs from Reinecke et al. So when it comes to custom and trade usage, the article by Hutchinson on customary insurance law are very important. He lists a number of informal risk spreading mechanisms, for instance stokvels, burial societies, and funeral parlors. He lists two more. You need to know the definitions of those and also the insurance law relevance of each of them. You also need to be able to distinguish those informal risk spreading mechanisms from more formal insurance mechanisms like funeral insurance and microinsurance. Study the article by Hutchinson in much detail and also then read the articles by Schultz. As far as legislation is concerned, the Long-Term and Short-Term Insurance Acts are relevant. Study from Reinecke et al. The paragraphs on the slide. You need to note that some of the parts of those acts have been repealed by the Insurance Act 18 of 2017, which is the new Insurance Act, but some parts still apply. Also note the Financial Sector Regulation Act and the COFI Bill, which is in its second draft. You also need to take note of the PPRs, the Policyholder Protection Rules. The Constitution and the Bill of Rights are the supreme law. It's also important that you study the Promotion of Equality and Prevention of Unfair Discrimination, Act 4 of 2000, as well as the article by Van Niekerk on discrimination and the relevant parts in Reinecke et al. Note that the Act is there to promote equality, and also have a look at the list of prohibited insurance law practices. Next, we deal with Learning Unit 5, the parties to the insurance contract. As I said at the beginning of this lecture, Learning Units 3 and 4 will form part of the second part of our lectures on Learning Units 1 to 5. You need to study from the study guide as well as the prescribed paragraphs from Reinecke et al. And then also attempt this question after you've done so. The insurer, the insured, and third parties are the most important role players in the insurance contract. First, as far as the insurer is concerned, refer to Tutorial Letter 102 and the notes on the repeal of Section 54 of the Short-Term Insurance Act and Section 60 of the Long-Term Insurance Act. Second, as far as the insured is concerned, there are many different possibilities. Have a look at your study guide for more examples. Then, as far as third parties are concerned, you need to distinguish them from intermediaries, insurance intermediaries, which are dealt with in Learning Unit 11. Now we deal with third parties. Learning Unit 11 deals with insurance intermediaries. So, you can become a third party in insurance contract by way of cession, by way of stipulations, or by way of statute. Some examples of stipulations are noted on the screen. The most important example of statute and third parties is contained in Section 156 of the Insolvency Act, and it concerns liability insurance. You learn more about liability insurance in Learning Unit 12. This brings us to the end of our lecture on Learning Unit 1 to 5, Part 1. Please do contact us if you have inquiries. The module leader for LML4805 at present is Mrs. Rafia Degama Akram. The way forward is to integrate all your study material. You need to study from the study guide, the prescribed textbook, the prescribed articles, cases, as well as additional tutorial letters. Listen to our recordings and also participate in the discussion forums and practice some questions. You need to visit the Moodle site regularly and note our announcements under the notice board and under the announcement tab. Also, refer to the glossaries on the Moodle site. Glossaries contain key terms and assist you with the language. Also take note of tutorial letters 301 and 302. They contain general information for all modules for the School of Law, and then 302 contains the referencing style for the School of Law. It's very important that you take note of it for purpose of answering the assignments. Also, again, I want to reiterate, study tutorial letter 102 for more on new developments and how your study material changed due to new developments. We wish you well with your studies.